So Amy, are we ready? Well, welcome to our estate planning SMARTS. I'm Berta Hansen. I'm the Executive Director of Community Care, and I want to welcome all of you that are here in person. We have a group of people that are watching this live online today, and it's also going to be recorded that people will be able to watch later. So welcome to all of those groups. This is an event that Community Care has been talking about doing for 3-4 years now. And we're glad that it finally came together and we're able to offer this important information. I just want to share a couple things. This is an educational event. Our purpose behind this is to help educate older adults, their adult children. As always, and I know there'll be a disclaimer with Susan as well, we encourage you to see your own attorney. But we're glad that you're here today. I do want to thank a few people before we start. Obviously, Susan Johnson-Brent, who I'll introduce in a moment. Jamie Spay, Jamie, who's our IT guy, helping to get all this recorded and promoted and things. And also First State Bank for their hospitality and letting us be here today. So, Susan Johnson-Brent, her practice areas include elder law, estate planning, probate litigation, guardianships, and trust law, including special needs trusts for the disabled. She is the only certified elder law attorney in North Dakota and northwestern Minnesota. Sue is a fellow in the American College of Trust and Estate Council and is the state chair for North Dakota. In addition to practicing law, which I think this is a wonderful fact, Sue continues to hold her licensure as a registered nurse in North Dakota. She is also the chair of the Elder Law section of the State Bar Association of North Dakota. Sue received her Bachelor's of Science degree in Business Administration and her Associate's degree in Nursing from North Dakota State University. Sue graduated with distinction from the University of North Dakota School of Law. Sue's practice is based out of Fargo, North Dakota, and she continues to be of service to clients across the local community, region, and country. I've had the privilege of hearing Sue 2 or 3 times and have enjoyed it thoroughly, and I'm looking forward to it today. So please join me in welcoming. Thank you.
Well, thank you for welcoming me, Dr. Castleton, today. As you're coming in, please pick up a handout. There's actually 2 handouts. One is several pages, and that's a copy of my slides with a spot to make notes. And then also there's estate planning terms and definitions. Now I'll be referring to the terms and definitions, and I am happy to work with any of you, but as the state chair for the elder law section for the bar and here in North Dakota, it's my job to encourage individuals to also see their local lawyer. And so please feel free to share my materials with your local lawyer and circle those things on the estate planning terms and definition sheet as I'm going through today's seminar for things that you might want to discuss with your lawyer. Sometimes it's hard to remember all of the wording, and that's why I put it here, so that it's easy to reference in the future. And so today is going to be like a little meeting with your lawyer about how to do your estate planning in case you become incapacitated, so that it's as easy for your family as possible to handle your affairs and to keep it out of court, and then steps you can take prior to passing away in addition to your will that you couldn't even do more than 7-8 years ago. Some laws have changed, and we're going to touch on those changes and ways that you can take steps to make things easy when you pass away, make it easier on your family. I've been doing this 20 years. This is my 20th anniversary this year. I'm looking forward to my reunion up at UND. And when I first started practicing estate law in 1997, we didn't have nearly the tools we do now to make things easier and less expensive in case of incapacity or when somebody passes away. But you have to know how the laws have changed, and you have to know what to ask for when you see your lawyer and what things might apply to you. So what we're going to be going through is financial power of attorney, also called a durable general power of attorney, same thing. Healthcare directive, Medicaid, which is a seminar within itself, but because of our aging population, I get so many questions on it that I do want to touch on a couple most frequently asked questions about Medicaid, and then also probate triggers your will and what some of those new tools to avoid a probate at the time you pass away. Now, financial power of attorney, durable general power of attorney, is one of the 2 documents that everyone in here should have, because I'm assuming everybody's over 18, and I'm assuming everybody's got at least a bank account or an IRA or some real estate where if you became incapacitated but didn't die, your family or whoever you trust would have no authority to take care of your affairs. And so we're starting on the very first thing on your estate planning terms and definitions, durable general power of attorney. And I like to show examples. I would never give the exact examples of one of my cases, but I might blur cases that are kind of interesting together to help make a point. So Nick and Emily are married. Nick suffers a severe stroke, and what I mean by that is he can't sign his name. He doesn't know what year it is. He's very confused. And he goes into the nursing home, and Emily's told it's going to cost $12,000 a month. And he'll get Medicaid, but he's got the stock account in his name, and Emily's found out that he can only have $3,000 in assets when he goes into the nursing home in order to qualify for Medicaid, and the stock account is bigger than that. But they have told Emily, with our rules, if you just move that stock account out of Nick's name and into yours, then he can get eligible for Medicaid. So go home and take care of that. Well, it turns out that only Nick's name is on the account, and Nick can't even sign his name anymore. So how is she going to do this? Can she sign the transfer forms? No. The only one who can sign the transfer forms are Nick when he was competent, Nick's power of attorney, whoever was named before he became incompetent, or she's going to have to go to court and start a guardianship lawsuit to have him declared incompetent and then get the judge's authority to transfer the stock to her. So what if she wants to sell their jointly owned home? She can take money out of their joint bank account. That's not a problem, but she cannot sign the deed for Nick. That had to be Nick while he was competent, Nick's power of attorney, or Nick's court-appointed guardian. At least once a month, I'll get a call from somebody at the hospital. My loved one's up in the hospital. I'm told she needs power of attorney. Can Emily sign that power of attorney for Nick? They've been married forever. No. No different than Emily signing a will for Nick. This is a document, this power of attorney, that's personal to Nick. And he has to sign it himself before he had his stroke. So, surprise, surprise, just because you're married doesn't mean you can handle financial matters for your incapacitated spouse. And some in here might be thinking, I already took care of that, because 15 years ago we went and signed wills. And I made my spouse the executor of my will, or my personal representative in my will. So my spouse can handle my affairs. Well, when you've got a power of attorney, that's when somebody's alive but incapacitated. The personal representative under your will is when you're dead. Nick is not dead here. So the will that he signed isn't even being opened or used at this point, and can't be. You can't use a will over somebody who's alive. So if you're married and you have an IRA, or your spouse does, you better have a power of attorney. Same with real estate, life insurance, or any assets in your name alone. Or some of the choices, like getting Nick on Medicaid, so Emily doesn't have to pay that $12,000 a month nursing home bill. But she can't do it because he's got a stock account in his name, and she can't sign the paper. So it's crucial that each person listed in the power of attorney have their own original in their possession. So let's say that I'm a single person and I've got 2 children, Brooks and Sherry, okay? And I name Brooks and Sherry both as my power of attorney. I wouldn't just sign the power of attorney saying Brooks or Sherry can sign for me if I'm incapacitated, and then I take that power of attorney and I put it in my safe. And I never tell Brooks or Sherry about it. And then I tell them at one point, well, I signed power of attorney just in case something happens to me. It's in my safe. It's in my safe deposit box. Are they on the box? No, so they can't even get into it. So then I get sick, and my daughter Sherry needs to go sign, write checks for me, pay my bills. Can she go into the bank and say, I've heard I'm power of attorney, I've never seen it, and expect the bank to actually write checks, let her write checks and take money out of the account? Absolutely not. So when you sign power of attorney, you sign one original notarized for each person that's listed on that document. Do you ever need to keep a power of attorney for yourself? No, because you'd never need it. The people who need to sign for you need an original power of attorney. If I need to sign my name, I just sign my name. I'd never be power of attorney over myself. It's important that you name alternates. I already saw one family today had powers of attorney. They looked proper, except husband named wife and wife named husband. Well, who travels together in the car all the time? Wife and husband. And so what happens if wife is driving, husband dies, wife in a car accident, and wife has a head injury, and somebody needs to take care of her bill payment? She doesn't have a power of attorney. It's like she didn't sign one at all. So you've got to have alternates listed. You have to have it in place prior to disability. It has to have the word durable on it. So my preference is you not download things off the internet, but if you do, make sure that the power of attorney document says it's durable. Otherwise, under our law here and in Minnesota, the minute the person becomes disabled, that you're supposed to have power of attorney over, you can't use it anymore. Durable means it continues beyond disability. That's what everybody wants it to be, but it has to have that word. It needs to be general. Sometimes that makes people feel a little bit odd, that the power of attorney says, all this language is hard enough to sign where somebody can take care of your bill paying, take money out of your IRA, and to think about the day you might be incapacitated. But the power of attorney your lawyer draws up is also going to talk about being able to handle your debt, being able to take out a loan, satisfy a loan, all of these things, and you're thinking, I don't want anybody taking loans out in my name. Well, when you sign the power of attorney, you might sign it in 2017, but it's not used until 2030. And who knows, in those next 13 years, you might take a loan out on something, and then you become incapacitated in 2030, and they need that paragraph inside the power of attorney that says they can take care of your loan. So the power of attorney should be general and talk about anything that you could possibly have. And if you're worried about whether you can trust the person that's listed on the power of attorney, if you're even thinking about that, whether it's they're at the casino too much, they're using drugs, their spouse influences them to spend too much money, whatever it is, if you've got second thoughts, they shouldn't even be listed. Because your power of attorney can do some crazy stuff with your assets. And it's your prerogative on who you list. Once they steal from you, it's going to be tough to actually sue them and get the money back, especially if it went into the slot machine or on the table to play poker. Then you should know all powers of attorney are null and void upon death. It's actually against the law to use the power of attorney after somebody's died. That's why you need the power of attorney in place in case you become incapacitated, and you need a separate will saying what happens when you die. You need two separate documents. It's usually the same person that you're going to list. Whoever's taking care of your affairs when you're incapacitated would seamlessly move into and have good continuity with the same person you've listed in your will as your personal representative. But if you're thinking, well, I don't need to put my children as co-owners on my safe deposit box because when I die, they can just use the power of attorney to get in. No, no, no. If they come into the bank and bring in your power of attorney to go in your box after you've died, they can get in a lot of trouble. And so instead, if you want that child to be able to get in your safe deposit box when you die without a legal proceeding, that child should be listed as a co-owner on the box so their access survives your death. So every adult, everyone in here should have a durable general or financial power of attorney, especially if you own real estate. And doing a guardianship and conservatorship is 10 times more expensive. And here's a little comparison chart. A power of attorney is private, a conservatorship is intrusive. And conservatorship is a guardianship over your money and your real estate. That's in the court system. Power of attorney, when you go to get your estate planning done, it's probably going to be about $300, give or take. Conservatorship, I ask for a $3,000 retainer to start, and that's my fee. Then there's a court-appointed attorney, a court-appointed physician, and a court-appointed social worker who all have to get charged, billed too, and then court filing fee. So it might be even over $5,000, just because you didn't sign power of attorney. Power of attorney, you sign it once. And as long as the people that you've named in there, your choice hasn't changed on who you've listed, you're good. Conservatorship, you're going to the court every year. And you're going to have to explain to the court how exactly you spent the money, if you sold real estate, etc. Power of attorney, you give the permission you wish. The conservatorship, you have to go to the judge and say, can I do this? May I do this? And the judge may say yes or no, and every time you do that, you're bringing a lawyer with you and it's costing more money. Power of attorney, you list alternates. If my husband can't do it, then my oldest son. If my oldest son can't do it, then my next daughter. With the conservatorship, if whoever's named as the conservator guardian can't do it, then they have to go back to court and find somebody else to do it. So it's just fee after fee after fee. Even when you die, your family's got to go back to court and ask the court to approve the final account and to be discharged. So even after you die, there's more attorney's fees. So again, sign before you become incapacitated. Best to sign it when you do your will. It's one of the 3 key documents that your estate plan should always be part of. The top 3 things on the terms and definitions: power of attorney, healthcare directive, and your will. Name alternates, sign an extra original, and be very wary of internet forms. Okay? When businesses, banks, insurance companies are looking to whether or not they're going to accept a power of attorney, someone who walks in off the street with a document called power of attorney who wants to do business on your account, oftentimes what they'll look at is what state's law is this based on. And if they see one done by a lawyer around here, they're going to see, oh, it's based on the North Dakota Century Code statutes about a power of attorney. Okay, we know what those are. We can wrap our head around those. So we know the limits of the authority of that person. But if you download something off of LegalZoom or whatever those, I'm not even sure what those are on the computer, it probably won't say North Dakota Century Code. I don't know if any North Dakota attorney has ever looked at and approved those documents. And so for the relatively modest cost of getting a power of attorney done, it's really good insurance for your family. Any questions about power of attorney? One thing I want to touch on, what if you've got 2 children, your spouse has died, you've got 2 kids, and you really don't want to treat one more in favor of the other? Can you name 2 people at once on a power of attorney? Sure. But when you name 2 people at once, you have to do another step. You have to say whether they have to serve jointly or if they can serve independently. If I'm serving jointly with my sister Sherry for our mother as power of attorney, that means if we go buy her a bottle of shampoo at Target, we both have to sign the check. So if you say your children have to serve jointly, they better live in the same town and they better have a similar schedule. So very rarely is it going to say serve jointly, because that's pretty unreasonable. So most times if you list 2 people, you want to put down that they can act independently, that one signature is just as good as the other. Especially if maybe one lives here in Castleton, Fargo area, and the other one lives out of state, like maybe Florida, but comes back to help once in a while. Then if they're co-powers of attorney, the one who comes from Florida can go do the banking and meet with the lawyer and meet with the accountant and go do this and go do that and help the one who's doing the work all the time. They can tag team each other. But now is not the time on your power of attorney to bring together two kids that have hated each other since the sandbox. Okay? And you know them if you have them in your family. And so if you know that your kids can't do anything but bicker, please don't put them as co-powers of attorney, or you will make the banker's life a living, you know what, and everybody else's. It's better that you choose who it is, and it be one at a time. Now, next document on your list.
One question,
Yes.
another question. Although I'm sure it's not recommended. What if you have 3 or 4? Can you have 3 or 4?
Question is, can you have 3 or 4 co-powers of attorney? Sure. But I wouldn't recommend it just because it's more cooks in the kitchen. Yes. But when I've got a client who is either can't decide at all who they want, unless they put all 4 kids down, or not having a power of attorney at all, I'll go ahead and put 4 kids down. But if a bank is going to be extra careful, even if it says they can sign independently, a bank or any business can say, I don't care, I want all 4 signatures, because I don't want 3 against 1 later. Okay. Yes?
Can you revoke a power of attorney once it's been issued?
The question is, can you revoke a power of attorney once it's been issued? Yes. You can do so either by signing a revocation of power of attorney or destroying all originals. And if you sign a new power of attorney in the future, let's say you signed one 5 years ago, now you want to redo it and who's listed on it. A good power of attorney drafted by a lawyer, the first line is going to say, I hereby revoke all prior powers of attorney. Okay, so any ones that might be floating out there are automatically revoked by signing a new one. So the next document in effect when you're alive but incapacitated is your health care directive. And we should be able to whiz by this because I'm sure everybody in here already has them because you can't go to the doctor without the nurse asking you, do you have an advance directive? Do you have a living will? Would you like a form? And they're free. But truth be told, over 50% of the clients that I meet with have been asked at their doctor's office if they have a health care directive. Sometimes have been given the form, but never filled it out because they weren't sure what was supposed to go into it. Well, for 10 years before I became a lawyer, I was one of the charge nurses in the cardiac intensive care unit at Medicare. And so if back in the early 90s, late 80s, you had heart problems, I might have been your nurse. And so when I do healthcare directives, and when I'm advising people how to fill out blank forms, I tell them exactly what your medical providers are looking for so that you don't procrastinate so much on doing the healthcare directive because you don't know what's supposed to go in on the lines. Now, a good attorney is going to ask you and interview you what your wishes are and then type them in, not have you fill in blanks, because you could have filled out blanks for the form that comes free at the hospital. If the attorney's charging you, you should get good service and have them type it all in for you. But the healthcare directive is not the old living will. Okay, the old living will from 30 years ago just said, when I'm on my deathbed and I'm unconscious, let me go, don't hook me up to machines. But it didn't say anything about who could make decisions for you. And so those old documents, if that's all you have, they do not comply with HIPAA. Does anybody know what HIPAA means? Health Insurance Portability and Accountability Act. Okay? It's that federal confidentiality law where if your medical information is spilled to anybody, it's a federal crime. And where you have to sign that your pharmacy can talk to Medicare and that the hospital can talk to your insurance company. You have to give a HIPAA release every year. That's what a healthcare directive, the first part of it does. It has nothing to do with your end of life. It just grants a HIPAA release to the people that you want contacted to make your medical decisions when you're so sick or you're so sleepy that you can't do it yourself. But at that point, they're doing everything possible to return you to the best health possible. It has nothing to do with pulling the plug. And then the second half of the healthcare directive is pulling the plug and what you want or don't want. And these are the end-of-life issues that need to be addressed in your healthcare directive. If you are terminal and in the dying process, do you want, when you're unconscious and not eating at that point, them to put tube feeding down? Or no, I don't want that. These are going to be the questions posed to your family. And it's better for them to know in writing what you wanted instead of getting to that stage and they're thinking, I don't know, we never had that discussion. We always talked about fun things. We didn't talk about this. And then they say yes or no, and then they're questioning their decision the rest of their lives. But if they're following what you put down, they've got a piece that they did the right thing. And so it's a nice gift. Do you want IV hydration? Do you want to be put on the ventilator? Or just get oxygen? And when you stop breathing, you stop breathing. And do you want your family approached about organ and tissue donation? So here's an example that's pretty real life to something that happened when I was a nurse. Lewis is 80 years old and suffers a severe fall. He's unconscious and needs surgery, but it's really risky. Now, if I had changed that to Lori is 35 years old and suffers a fall and needs surgery, that's where it would end. Because the emergency room would just use implied consent law, even though she's unconscious, and take her to surgery because she's 35. But Lewis is 80, and he's got diabetes, and he's had an amputation, and he's had this and that. And what's the hospital worried about if they take Lewis to the hospital, into the operating room and nobody signs a consent? Lawsuit. They want somebody to sign off on this. And he can't do it, he's unconscious. Never signed a healthcare directive. He doesn't have a wife, but he's got 8 kids. And they don't agree on whether or not he should have surgery. So what does the hospital do? What if he becomes terminal? What do they do when the kids can't agree? And what if he needs tooth feeding? They all have equal priority for consent. So in a perfect world, on Lewis's chart would be his 8 kids' names, his 8 kids' phone numbers. They would all answer the phone and they would all agree. Okay? That's not going to happen. So then the hospital legal department is going to call a law firm like mine and others and say, we need you to come up to do an emergency guardianship. And who's going to pay for that guardianship? I'm going to ask for a retainer. Whoever the child is, whichever of the 8 kids has decided they want to step up and be guardian. So they're going to have to get their checkbook out for $3,000. And instead of being up at Lewis's bedside, they're going to be at my office. Instead of being at his bedside, we're going to court. Not fair to that child. So he should have chosen a decision maker in a healthcare directive in advance. And it's best to have alternates. And there, if the first person doesn't answer the phone, they go on to the next person. You can name 2 at once, but I highly recommend you don't. Otherwise, the hospital may feel that they need to contact both of them, and what if they don't agree? Then you're back to square one. But then Lewis can make sure that all of his wishes are met, or to the best extent possible. When I look over a healthcare directive that somebody's filled out, some of the errors that I see, number 1, it might be nicely filled with their one son that's a nurse, and then their next daughter that's a nurse, and they've got all the address and names there, no phone numbers. Make sure you put down all the numbers that your child can be reached at, because they're not going to write a letter about your emergency healthcare issues. You need a phone number. The other thing is it has to be notarized or witnessed by 2 people. So when you get done filling it out now, you're all proud of yourself, and then you sign and date it. It's not legitimate because you didn't have a notary. So you got to wait to sign it until there's a notary there. Okay. When you do your healthcare directive, every person should have a photocopy. That was different than what I said about powers of attorney. Powers of attorney, each person listed needs an original. Healthcare directive law is more informal. And so you do one, then go make a bunch of photocopies. One for yourself, one for each child listed, person listed, one for your primary doctor. What if you get shipped down to Mayo? You should have one to put in your suitcase. What if you go to Arizona? Same thing. North Dakota will soon be offering a depository to put your healthcare directives, but that's probably not going to be till next year. So those are the 2 main documents, power of attorney and healthcare directive. Any questions before we jump into Medicaid? Okay. Medicaid, there's a few people in here who probably don't know this and might not know even to ask. There's a difference between Medicaid and Medicare, okay? How many of us have worked and have money taken out for Medicare from our check each month? And Social Security, yay, and we don't like it, okay? But then when we become disabled or we hit age 65, we apply for Medicare. For those of you that are on Medicare, does Medicare ask you how much money you make each year? Or how much farmland you have? Does Medicare care what you own? No. It's an entitlement. You get it because you paid into the system. Okay, so Medicare will be there, hopefully. Okay? Medicaid is not an entitlement. It's an eligibility program. No different than trying to go get food stamps or go get heating assistance. You have to show that you meet the requirements to get Medicaid before you do. It's not that, oh my, it's so expensive to be in the nursing home. There should be somebody out there to pay for it. It should just happen. No, you need to set up all your ducks in a row long in advance before you need Medicaid to maximize what you and your spouse are allowed to keep. You don't wait until the steps before somebody goes in the nursing home. It's all about pre-planning. And so before I go into the specifics, I'll give you a little overview. If you're single, you're allowed $3,000 in assets. If you're married, there's a formula. But overall, if you need Medicaid because you need long-term care in a nursing home, in a memory care unit, in your house, I'm not talking about Medicaid for a 19-year-old pregnant unmarried woman. That's a different kind of Medicaid. I'm talking about long-term care. You need three things to get long-term care Medicaid in North Dakota and Minnesota. You have to be down to the asset limits, that's number one. You have to have somebody who requires that level of care under doctor's order. And then the big one that nobody likes, you can't have given anything away to anybody for less than fair market value in the last 5 years. And we'll touch on that again. So Medicaid limits, if you're a single person, you're called an institutionalized spouse. You have to get down to $3,000 in assets. If you're married, your spouse that's receiving long-term care services is called an institutionalized spouse, and the healthy spouse is called a community spouse. In North Dakota, the community spouse is allowed 1/2 of the assets, not to be, it's not working on there, not to be less than $24,180, and not to be more than $120,900. And so if my husband and I together in North Dakota had $100,000 and I put him in the nursing home, I as the community spouse can keep $50,000, he can only keep $3,000, and we have to show how we legally got rid of $47,000. Now in Minnesota, last year the law changed. They don't have half fees anymore in Minnesota. If my spouse goes into the nursing home, I'm allowed the first $120,900. And so if my husband goes into the nursing home and we're Minnesota residents, I'd be able to keep the whole $100,000 because it's under $120,900. So there's a benefit there to be on the Minnesota side. Those are the asset limits. Income limits, if I put my husband into the nursing home and I've got a higher income or any income, I get to keep it once he gets on Medicaid. Once he gets his Medicaid card, none of my Social Security, my wages, my pension have to go towards his care. And if my income as a community spouse, when my husband's in the nursing home, is less than $25.50 a month, I get some of his income to help supplement my life every month before it goes to the nursing home. In Minnesota, it's only $2,000. You can see why this is a whole seminar in itself. When you're looking at Medicaid, and the first thing about asset limits, what do they count against you? Anything you can make available at your disposal, whether or not you want to. So any bank accounts and investments, for the last 2 years in North Dakota, they do not count IRAs, 401ks, 403bs, any qualified SEPs, any qualified retirement plans. You can make available annuity balances, the cash value of your life insurance. You got this life insurance in your 30s when you first had kids. You don't even really know what it's worth. But come the time you or your spouse enter the nursing home, they'll make you get a printout showing the death benefit and the cash value to see how much you could cash the insurance in for, and that's going to count against those asset limits. A second vehicle, real estate other than your primary home, and 529 plans. And in the last 10 years, I've had 3 different advisors, investment advisors, who told their clients, oh, your spouse has dementia, your spouse has Parkinson's. I know the way to help. Let's put all of your extra money into 529 plans. And then it's all protected for your grandkids, and it can't be taken by the nursing home. Well, for those of you that know about 529 plans, you know that you can get them back with a 10% penalty. And so in every case, they had put hundreds of thousands of dollars under their broker's advice into a 529 plan, put their husband in a nursing home, got denied Medicaid, and were told to go cash in the 529 plans. They had to pay the 10% penalty. It was bad advice. If you're married, what else can you keep? You can have some contiguous farm acreage. So if you live rural and if you live at the farmstead, you can have some acreage as long as it's attached to your farmstead and not separated by land owned by others. You can have a reasonable vehicle, and many times as we're getting ready to get eligible, we'll use some extra money instead of it going to the nursing home to update the vehicle. Personal effects, they don't care if you've got a 3-carat diamond ring or gold jewelry in your house. They don't count that against you. Income producing assets, if you happen to own a store or a farm and that's your way of earning a livelihood, then you're allowed certain business assets in addition, and then very specific funeral accounts. Here's some of the stuff nobody likes. If you're sleeping, wake up. This is what you need to hear, okay? This is so kind of dry and dreary, but this is important stuff because there's so many urban legends and there's so much miscommunication about this. You can impress your friends saying you know these rules, okay? So before February 8th, 2006, that was when the line in the sand happened with Medicaid law and giving things away. Before that time, it was 36 months if you gave it to people and 5 years if you put it in a trust. Now, after that date, there have been no other law changes about this. Okay, so that's a big urban legend. This is still the law. Uncompensated transfers or gifts by an applicant or spouse. So if I give something away, it affects my spouse and vice versa. To individuals or certain trusts within 60 months of meeting Medicaid on an application will, not might, will cause the applicant to be ineligible for Medicaid for the period of ineligibility. What do they care about? In the last 6 months, I've had somebody penalized for charging their farming son less than fair market rent. That was a gift. I've had somebody penalized for paying for a plane ticket for a daughter to come up to a funeral. I've had somebody penalized for $100 Christmas presents. I told you, everybody's going to get sour face now. But don't kill the messenger, okay? You need to have knowledge so that if you don't know and you get to where one of you or your spouse or your parents need to go to the nursing home, that you aren't blindsided with these rules. Now, is this an entitlement? Nope, it's eligibility. And so it's Medicaid's rules, Medicaid's ball, Medicaid's field. You're just invited there. And if you don't follow their rules, there is no eligibility. Here's an example. March of this year, Sharon gives each of her kids $2,000. She sold her house, moved to an apartment, and thought, I've never been able to give my kids this kind of money, and how nice to be able to do it. Okay, she wasn't trying to get around Medicaid or anything. She just thought, how nice. I'm going to give each of my kids $2,000. Total gift of $10,000. She's a North Dakota resident. That $10,000 total, not per child gift, that's an error, results in a 2-month period of ineligibility for Medicaid. Let me show you how that works. So she gave $10,000 total. Let's say her oldest daughter's name is Bobby. And Bobby's the power of attorney. Months after Sharon makes this gift, she ends up getting sick. And she burns through the rest of her money from the sale of her house in the nursing home. She's down to $50 in her pocket. Her Social Security check for $750 a month, and her nursing home care is $9,000 a month. And it was just a few months after she did this. So her daughter Bobby goes, Sharon's not doing it. Sharon's in the nursing home. She doesn't know what's going on. So Bobby goes and she fills out the Medicaid application. And the application says, what did Sharon give away in the last 5 years and get back less than fair market value or nothing? And Sharon never gave money for birthday, never gave money for Christmas, wedding, graduation, never put money in the church plate. So all she did in these 5 years was this $10,000 cumulative gift. If she would have done birthday, Christmas, church plate, those would have had to be added in too. And they add up everything she gave over 5 years, and how do they know? They ask for 5 years of bank records, including canceled checks. Then they take that $10,000 that she gave away, and they divide it by the statewide average printed from Bismarck January 1st of every year, which is $7,845 a month. And they say, Sharon, if you would have kept that 10 grand, you could have paid for 2 months of your care on an average care. Now her care is $9,000, but they don't look at that. They look at how much an average person would pay. So they're telling Sharon, you gave that $10,000. If you need Medicaid in the next 5 years because you're broke and you're in the nursing home, you have to pay for the first 2 months of your care, and we're not going to give you any help at the point when you've got $50 in your pocket. So she made the gifts on March 1st, 2017, then the 2-month waiting period is hanging over her head and doesn't fall off until April 30th of 2022. So she's in the nursing home during that time and she's broke. Then she has to pay for the first 2 months of her care when she's broke. So if she's got $50 in her pocket and she makes $750 a month Social Security, and she has to pay for 2 months of her care at $9,000 a month, how does that happen? She will get the money back from her children, including suing them, getting a judgment, putting a lien against their home, garnishing their wages. She has to sue it to the hilt. She can't just say, my kids spent it. You know, they got Christmas presents for their kids and they sent their kid to college and it helped buy them a new car. I'd never given them any money before. I had no idea this was going to hang over my head for 5 years. Okay? Sharon is at risk if she doesn't do that of being kicked out of the nursing home. Did you know you can be kicked out of the nursing home? Yeah. There's no safety net to pay for the people that don't get Medicaid. If you're in the nursing home and you're not paying the bill and you don't have long-term care insurance and you don't qualify for Medicaid, who's paying your nurse to take care of you? And so you will get a letter saying you're going to be discharged in 45 days for non-payment. And where will you be discharged to? Your kids. Happens all the time. Okay? So again, everybody's just like, oh my God, I can't believe there's this big trap door you can just fall through like that. You've got to know what your rules are. Okay? So there's no Medicaid until she pays for 2 months of her care when she's out of money. And one of the biggest traps is not paying fair market rent. Okay? Because the financial workers, especially in North Dakota, are very educated on looking and seeing what the average rent is in the county in which your land is, whether it's irrigated, non-irrigated, or pasture. And if you don't make sure that your rent is under that schedule, you could be deemed with having your tenant, who might be a son or a third party, having to retroactively pay fair market rent for the prior 5 years. And they also make you go to year leases. You can't lock in a low lease. So Any and all uncompensated transfers made by an applicant or spouse to an individual or entity for any reason, gifts, presents, church, charitable donations, tuition assistance, etc., after February 8th and within 5 years of needing Medicaid must be reported and will affect eligibility, and it's a felony to lie. There's no federal exception for nominal amounts or charitable intent. Prior to February 8th of 2006, you could do $200 a month total to anybody you wanted. So that meant you could do church and some modest Christmas presents and that type of thing. After February 8th, 2006, each financial worker in each county is supposed to penalize every dollar that you didn't spend on yourself. So property and asset protection planning has to begin 5 years before you need Medicaid. So before we get to this slide, who in here has heard of filial law? F-I-L-I-A-L. North Dakota has had it since the 1880s. Filial law predates Medicare. I don't have a slide on it. It predates Medicare. And it says that children are responsible for the care of their parents. And so if in these slides, Sharon doesn't get the money back from her kids, it allows the nursing home to sue the kids to get the money back. So even if Sharon isn't willing, the filial law will allow the county or the nursing home to sue the children. Minnesota does not have filial law, North Dakota does. Sharon's kids didn't sign the contract with the nursing home. Maybe they haven't talked to her in 25 years, but under North Dakota law, they're responsible to pay for any care she doesn't cover for herself in the nursing home. I was interviewed 5 years ago for the form on filial law, and the fact that I thought it was crazy that children would have that liability. And then they also interviewed Judy Lee from West Fargo, and Judy Lee said they were familiar with filial law and that North Dakota has no intent to revoke it because it's a way to make sure that children are responsible if they get gifted money from their parents to give it back. Okay. All right. I ain't political, but I just want you to know what's going on out there. Okay. So as far as planning for the next step, which is why we are here, here's one of the biggest tools we still have in North Dakota. South Dakota doesn't. They put the line in the sand. If people try and do this with their land in South Dakota, nope, doesn't work anymore. Try and do it in Minnesota, there's a state lien against it. North Dakota's is still platinum. It hasn't been touched by the legislature. I don't think it will be anytime soon. So if you have real estate that you want to protect, go down to number 5 and circle it. You're on life estate deed on your terms and definitions. It still works 100% in North Dakota. If you've got a house, hunting land, farmland, mineral rights that you don't want to have to sell and use for your nursing home care, this is what you do. It is not a trust. There is no trust in 2017 that you write in 2017 that says trust at the top unless you're disabled yourself that will protect your property from the nursing home. Okay? And it's not a trust, it's a life estate. If you have a revocable living trust, it does not protect your property from the nursing home. Because what's the first word in that deal? Revocable. So if you go to the nursing home and you've got all your land in your revocable living trust, it's really good for tax planning and other purposes. I do lots of revocable living trusts, but not when my clients want to protect real estate, because then it has to be taken out of your trust and used for your care, because it's revocable. This is irrevocable. Tim signs a quitclaim deed placing his property into life estate with his children, which means Tim has the right to live on the property if it's got a house. He can rent the house, or he can rent the farmland, or get the mineral income, get the royalties, get the bonus payments, but he's responsible for all expenses. Property taxes, the roof goes out, the well goes out. His children should have no expenses. The value of the life estate in North Dakota is excluded. And so when they're counting that first thing that you need, remember, you need down to asset limits, need long-term care, and not have given anything away in the last 5 years to get eligible for Medicaid. Here, they don't count it towards that asset limit. It's excluded. So it's the best way to protect any real estate or mineral rights from having to be sold to pay for long-term care, that you're subject to the 5-year look back. So you don't do it the day that you can't take care of your wife anymore because she's home with Parkinson's and dementia and you've reached your limit. You should have done it when she was diagnosed 5 years ago. Okay? And so you want the 5 years to start when you sign the deed. It doesn't start when you enter the nursing home. So you sign the deed 5 years before you're broken in the nursing home, and that protects the property. The income generated from the property has to go towards your care. So if there's cash rent off the farm, royalties, those will go towards your care. But the land itself, the property itself, they cannot force the sale. Any questions on life estate? Yes, in the back.
Property need to be in North Dakota as well, or just need to be in North Dakota resident? So can the real estate be in another state?
Question is, if somebody's seeking North Dakota Medicaid and they say have a life estate on their lake property in Minnesota, is that okay? Yes. And so if somebody's got property in South Dakota and seeking North Dakota Medicaid, and they've got a life estate on their property in South Dakota, fine. But if they're in South Dakota and seeking South Dakota Medicaid and have land in North Dakota life estate, not fine. So it's wherever they're seeking Medicaid from and what those laws are. Any other questions? Yes.
Does that property have to be owned, or can you be paying mortgage on it, or?
Question is, does the property have to be paid off, or can you still have a mortgage on it? Well, when Tim signs the deed over to his kids at the courthouse, it's going to look to any lawyer or bank like his children now own the property, and Tim has the squatter's right, but he's only got the right to use the benefit from it for his lifetime. And so you put the bank in a different position because the kids never gave him any credit report or signed the promissory note or signed the mortgage. And so it's always best to get written permission from the bank that they're okay with Tim doing this. Otherwise, if Tim does this and never tells the bank, even if he's still current on his mortgage, if they wanted to be very picky, they could say, you better undo that life estate or your mortgage is due by the end of the month. But I certainly do it with mortgages on the property. I just do it letting the bank have full knowledge. Any other questions about, yes?
My family had a life estate, and the one thing we discovered with our renters, we had to redo the contract so that they paid the property taxes before the money came to my mom.
Correct. You have to do a net lease.
That was one key change.
Correct. Because if Tim goes to the nursing home and he's getting $30,000 a year off of his cash rent, well, the Medicaid wants to know that they can use that $30,000. They don't want Tim to, or his power of attorney at that point, to say, well, I've got to pay $4,500 for property taxes, so you don't get to keep the whole $3,000. So instead, you have that all incorporated in the lease with your tenant, so those taxes are taken care of. Any other questions? Yes?
The difference between life estate and irrevocable trust.
Question between life estate and irrevocable trust. Interpretation under the law. If you were to put your land into an irrevocable trust, and the language says that you keep the income off of it for life, and then when you die, it is owned by other people. There have been cases in North Dakota where if you end up in a nursing home and broke, even after the 5 years, they make you go to court to try and break your trust. And actually, in July 2010, I think it was 2010, in Minnesota, they actually passed a law saying if you do an irrevocable trust after that date, in the context of trying to protect something from going to the nursing home, if your trust is signed after that date, they deem it to be revocable. And you cannot qualify for medical assistance Medicaid in Minnesota until you go to court and get everything back out of your trust. And so Minnesota actually passed the black and white law that put the line in the sand, the days of the trust before are okay and the trust after are not. North Dakota doesn't pass the law, but has the interpretation. Now, that's if you set the trust up for yourself. If you inherited the trust from someone and it's an irrevocable trust, then it's probably fine. But if you go to a lawyer and are given the choice of doing an irrevocable trust or a life estate, I would draw your attention to fifth from the bottom, irrevocable living trust, and the last bullet can no longer be used effectively for nursing home asset protection. If it's an old one, it might be grandfathered in, but otherwise it's pretty risky. Any other questions about life estate? How about putting your kids on an account with you? Mark owns a bank account with his kids as joint owners. Is that a good idea? No. Will they treat those accounts as Mark's? Yes, when he applies for Medicaid. And so sometimes I'll give seminars and I'll have someone who's sitting there, yeah, she's got it all figured out. Yeah, no, I've got it all figured out because I've got 3 kids and I've got 3 CDs and I've got 1 child on each CD with me and there's no way the nursing home can take those because my kids are on them. No. Unless each child can prove contribution to that CD, that child actually put money in it, under the law, it's considered 100% loans. Okay, so that doesn't help. So, just a couple things to wrap up. Probate. Okay, Myrna, I've got a will here, and I've got $1 million lake home on Pelican, and it says here, I give my Pelican Lake home to Myrna. And I died yesterday, okay? So when I do a will, that's all that's needed, right? Because now you can just go get my $1 million lake home. You can just go to the courthouse and have them turn it over, right? Because my will says so. Sounds too good to be true, right? But that's what a lot of people think, is when you sign a will, that's all you need. Now it's going to be easy when I die for my family to handle things. Well, what Myrna finds out when she goes to the Otter Tail County Recorder's office and says, well, see right here, Susan was so generous, she gave me her lake place, right there, paragraph 2. I'm here to collect that now. Okay? No, you can't do that. Instead, they're going to say, how do we know, Myrna, that you didn't forge this? Because Sue's been married to Dan for 34 years, and that seems a little bit suspicious, okay, that she would just disinherit him. And so we need to make sure that Dan knows about this will and see given his day to object. And didn't Sue die in the ICU and she's got a bunch of creditors? Don't we need to make sure that they get paid off too? So instead, your will, when you die, is important, but all it's going to do is go to a probate judge through a probate lawyer, and the judge is going to look at your will, and the lawyer is going to send it out to your family. And then there's going to be a probate proceeding in the court where there's a personal representative appointed, publishing in the paper a couple times that you died in case anybody was injured on your property and wanted to bring a lawsuit. And then there's an inventory and accounting, all kinds of things. And that's what probate is. Now, what would happen if instead I signed a beneficiary deed to Myrna that said, when I die, if I still own this place, I've already listed Myrna as the next beneficiary to own it at Otter Tail County Courthouse, and I recorded that. And that's the fourth thing on here, transfer on death deed. If you did your will more than 7-8 years ago, this did not exist. So it doesn't protect it from the nursing home, but it protects it from probate, where you can list beneficiaries on real estate. You never could before. It doesn't transfer to them until you die, no different than putting beneficiaries on life insurance. But then, if that paper is at the courthouse, Myrna just takes my death certificate and bam, she owns my Pelican Lake home. I don't have one. But if I did, she would own it. Okay? Did that go through my will? No, it went through a will substitute. And that's all what it's about today is will substitute, and finding ways to avoid the costly expense of probate. I had one Fargo Moorhead attorney that charged $40,000 to do a simple probate, and the personal representative charged $130,000. I was hired by somebody who was inheriting, saying, there should be $180,000 in fees. And we went to court and had the attorney get nothing and the personal representative get nothing. But when you go to do a probate, and I've got 2 full-time probate paralegals, because unfortunately people do not take these steps ahead of time. But when you do a probate, it's going to cost you at least $3,000, if not $5,000. And if you've got real estate in more than one state, you're going to double that, because the real estate is handled by the courts in the state in which it's located. And so if you've got a place in North Dakota and a place in Minnesota, pay attention. So a will doesn't avoid probate. It's a roadmap. You're speaking from the grave to the probate judge on how you want your estate to be handled, who should be in charge, and who should inherit. Last sentence is important. If you're inheriting through the will, if you're inheriting because there's a paragraph in the will that says you're supposed to get some money or some real estate, your family's in probate court. Because you can't take your will to the bank here and for your parents when you die and walk out with money. No different than Myrna couldn't go to the courthouse and walk out with real estate. You need a judge's order. How is it caused? There's a real estate rule and there's a non-real estate rule. First of all, think about what you own, do a mental checklist. Is there anything that you own that doesn't have a joint owner, doesn't have a beneficiary, or isn't in a trust? That means you're all alone. No joint owner, doesn't have a beneficiary, and you don't have a trust. Then if it's any value of real estate, bam, in North Dakota, you're in probate. Because there is no, if it's only worth, it's a lot in some town that's now a ghost town in North Dakota, the lot is worth $50. Doesn't matter. Any value of real estate causes a full-blown $3,000 probate. If it's not real estate, if it cumulatively exceeds $50,000, or in Minnesota, $75,000. So, real estate. How to avoid it going through probate. Quick example, and if you've heard me speak, this is an example I've used frequently. Woman came to see me at the previous law firm I worked at, Vogel, and she had stage 4 cancer. She was in her 50s. She was going to die. And she had young kids. Husband, and her doctor has said, you're only going to live a couple of months. It's time to get your affairs in order, what no one wants to hear. And so she had reached that step of acceptance. And she was there meeting with me. She wasn't teary. She wanted to make sure everything was set up. In my form letter that goes out before I meet with someone, as with most estate planning attorneys, I ask that you bring all of the deeds to your property. Well, they didn't understand why I wanted the deed, and the husband was the one pulling everything together, and he decided I didn't need the deed, that I was just looking to make work for myself. And so when I was going through their information, I said, do you have the deed to your home here in Moorhead? And the husband said, you don't need that. And I said, well, I just want to double check that the deed says joint tenants on it, because when Becky dies, which she will, I want to make sure that it passes to you automatically as a joint tenant, like on a joint checking account. If it's not listed as joint tenants, then we've got a probate for Becky for her half to go to you. And it's an easy fix. I can have Becky sign a new deed, but I need to see your old one. That's fine. We're both on the property tax statement, honey, don't worry. Your property tax statement has nothing to do with how you own your real estate. So you cannot hang your hat on that. If you are married and you're not sure if your property is joint, I'll tell you how to find out. But what happened is Becky's husband came to see me a month after she died. He was kind of like this. He said, here's her deed, and I don't see the word joint tenants on it. And I didn't believe you, Sue. So I went over to Clay County Courthouse, and you're right. I don't get her half of the house. Because it wasn't joint, she owned 50% and I owned 50%. And even though we've been married for 15 years, I don't get her 50%. I have to go through probate, publish in the paper twice that she's died, have a hearing. It's going to cost me thousands. And how much would it have cost me if she would have signed it before she died? I said $150. And so I couldn't make him bring it, and it was wrong. So if you're married, don't rely on your property tax statement. You should have the title to all of the real estate you own. Even if you still have a mortgage, there is a deed. Just like having your car title, there is a deed. And you go to, interestingly enough, your property tax statement, and on the top, the property tax statement, there'll be a PIN, the property identification number, about 12 digits long. Take that property tax statement, doesn't even have to be the current year, because the number stays the same. Bring that to the recorder's office wherever the property is located. So if it's here in Castleton, go to Cass County. If it's In Valley City, go to Barnes County. But bring it into the recorder's office and say, I don't have a copy of the deed when I bought my property and I'd like one, please. And then they'll say, okay, do you know about the year you bought it? You give that to them and you say, here's the ID number, and then you just made their job easier. They'll probably charge you nothing, maybe $2. And then you have a photocopy of your deed. Then you can look and see if it says joint tenants on it. Then if your spouse dies, it automatically comes to you. No probate. If it doesn't say joint tenants, you're going to have a probate. And if I see 100 deeds, the 10 of them that I see screwed up are usually new construction compared to buying existing property. I don't know why. Okay, but about 10% of the deeds that I see are screwed up, and it's usually new builds. The contractor gave you a deed for a single person rather than a married couple. But these are the only 4 ways in North Dakota and Minnesota to avoid probate on real estate, either home, farmland, or minerals, when you die, as a single or married couple. It has to be joint, have a beneficiary deed, have a life estate like we talked about, or have it owned by your trust. There are no other ways. So if you don't have those, your family's going to go through probate. So check your deed once you pick it up. If it says as husband and wife, not good enough. If it says and, that's not good enough. As tenants in common, not good enough. It's a legal term of art. It has to say as joint tenants, period. If it doesn't say joint tenants, see your attorney to have a new deed done, and it's going to be usually $250 or less, and the filing fee, which is now about $20 in North Dakota. It went up. Transfer on death beneficiary deed, that's that new law where you want the right to be able to still sell it. You don't want that nursing home protection that you set aside your real estate irrevocably. You want to have it revocable, so if you want to sell your house or your property, you don't have to ask someone. But you also want to use a will substitute so it doesn't go through probate. That's the transfer on death beneficiary deed. Life estate deed, again, that's the best one for protecting it from the nursing home after the 5-year look back. Single or married, you can do any kind of real estate. You get the right to the income for life, but what you lose is the right to be able to sell it without the co-signatures of the people you gave it to. But if you still have the right to sell it and do whatever you wanted, it wouldn't be protected from your nursing home costs. So it's the irrevocability that is actually what's causing the protection. Because if it's been deeded over to your kids for at least 5 years, and you need Medicaid, and the nursing home or the county says, you've got a section of land out there, why should you get Medicaid? You can say, hey, I didn't make the law, but that section isn't going to be sold now. You can have my income off of it, but that section of land is technically owned by my kids, and they're not in the nursing home, and they're not applying for Medicaid, so they won't be feeding it back to me. Revocable living trust, do less and less of these compared to what I did when in the 90s, before we had transfer on death deeds, and when we had that low $600,000 estate tax exemption. And so we need to have a reason to do it, multiple state real estate, that type of thing, or a large estate. Accounts, make sure you put beneficiaries on your accounts. Again, think about, what do I own? Is it joint? Does it have beneficiaries on it, or is it in a trust? So if you've got checking, savings, bonds, annuities, IRAs, make sure that you have beneficiaries. All right, that brings us to the end. Thank you so much for your attentive listening. And now we're going to be taking questions from the off-site. And any questions that anybody has here. If you've got a private question you don't want to ask in front of the group, I'll stay as long as needed. Yes.
Are you saying that the joint tenant ownership, the life estate deed, etc., you should have one of those or two of those?
You can actually have both. So the question is, am I recommending joint tenancy and life estate? Well, of course, it depends on your situation. But if you're a husband and wife and you've got a quarter of farmland that you inherited from your parents, and you don't plan on selling that quarter of farmland for your retirement, then you would, and you want your spouse to still get the income when you die, then first you would make it joint with your spouse, and then you would sign the life estate deed over to your kids, retaining a joint life estate. So then both of you get the income, one of you dies, mom still gets the income, both of you die, the property goes to the kids. And you do that 5 years before you need Medicaid.
Okay, I have opened up the conference, the webinar lines, if anyone has any questions you would like to.
If you've got a revocable or irrevocable, likely revocable, right? So he doesn't have to. If your assets have been attached to it. Because your revocable living trust, think of it like a bowl, okay? And let's say that you own some land. When the lawyer did your trust for you, he probably transferred your land to your trust, you as trustee of your trust. So now your property tax statements mention your trust. And your lawyer, if they knew about life insurance, probably would have changed the beneficiary of your life insurance to your trust. But let's say years after you did your revocable living trust, you went and bought a condo and you just put it in your name. You still got the trust here, but you never connected this condo to your trust. And so when you have a revocable living trust, you need to make sure that it's already in the trust or designated to go to the trust or other people when you die. Otherwise, you've got this loose item out there that will cause a probate. If it's real estate of any value or cumulative non-real estate that exceeds $50,000. So just by saying you have a trust doesn't mean you're avoiding probate. Saying you have a trust and that it's funded, meaning that everything that you own is attached to the trust, that avoids probate.
Okay, so then if I would, so we set up a revocable living trust. And then it has to be taken care of. I mean, what kind of document, taxation documents you have to file, don't you?
A revocable living trust doesn't have separate taxation. It's under your social security number. Until you die, when your social security number can't be used anymore, and then let's say you leave your trust for your wife,
Yep.
Then your wife has to go get a tax ID number. One of those numbers that starts with 2 and then a dash. 2 numbers and then a dash, because they can't use your social after you've died. But while you've created a trust for yourself, the IRS says just use your social security number. If you inherited a trust from somebody else, then you have to go get a business employer identification.
Does she pay the taxes? Supposing it's X number of dollars, unless we do away with estate taxes and things like that.
You're talking about estate tax, not income tax.
No, I'm not talking, I suppose estate taxes.
Oh, okay. Yeah, estate tax, by having a revocable living trust, doesn't avoid estate tax, but the lawyer will put language inside of it to minimize the estate tax. Like I just met with a client who has $45 million right before I came here. When he dies, the most that's going to be excused from estate tax is about $5.9 million. The rest of it, his kids are going to have to pay estate tax of 40%. And he has a trust, but just because he has a trust doesn't mean he can pass $40 million without estate tax.
Okay, my other question is, as I'm going to mature age now, down through the years, there's siblings out there with families and they have problems and it's tough to settle those estates or to make a will, or how do you, can you tell me something about mediators or something like that to bring in so that things can, I read a couple articles on that it's possible to do something. How does that work out?
Well, usually what happens if there's a fight when somebody dies or a fight when...
Can you prevent it before it is?
Oh, heavens no, you can't prevent it before.
You can't? Can't you bring them all together and try by the mediator to help?
No, that, you ever tried to stop a fight from happening on Thanksgiving? If it's gonna happen, it's gonna happen, and then you try and settle it down. But no, there's no way to stop somebody from challenging your will.
You can't settle some estates equally. Some do more for their parents than other ones do.
Correct.
And so that has to be taken into consideration, I would think.
Yes,
So with a mediator, something like that could be brought,
Correct.
to at least talk about it.
correct. But somebody has to bring the challenge first.
We
And I
have
just say,
a,
we've got some questions from our remote sites, so if we can get to
Yep.
those, and then maybe you can continue with the question after. if we have-
Sure.
we do have one question that was entered in chat. I think I have it open here. If I have a irrevocable trust and I apply for Medicaid 3 years after creation, what are the implications for the trust?
Okay, so if you have an irrevocable trust that has assets in it and you created it 3 years before you apply for Medicaid, unless you did it as a disabled person under age 65 with what's called a special needs trust, in all likelihood, you're gonna have some grief with the county about that trust. They have to send in a special trust form from the county to the Assistant Attorney General at the North Dakota Department of Human Services to know how your trust is written, what's in the trust, and how it's used. So it'll be highly scrutinized, and in all likelihood, you'll be required to go to court and break the trust, unfortunately.
Just one second here. Travis, I've unmuted you. Do you have any follow-up?
Yeah, I'm not prepared for that. I'm sure I live in Colorado, so well, I'm not studying for sure. So I don't know
I will put it as a no.
Any other remote questions?
Oh, he just typed in no, so no other questions. I do not see any other questions. If there's anyone else with questions remotely, please enter them into chat.
All right, well,
I
thank you
have
so much.
another
Oh, yes, go ahead.
question. On the Medicaid deal, where you say bank accounts do not hold,
With your kids.
that's not the same as time of death beneficiary.
Correct. The question is, having your kids on as joint owners is not a good idea for Medicaid. Is it a good idea for putting them on as beneficiaries of your account? Absolutely. All right, well, we'll wrap up with Myrna's last statement. Oh, yeah, go ahead.
It's kind of a silly question because I'm not sure I grasp this whole idea. Obviously, you do not know 5 years before you might need it, Medicaid.
Obviously.
So you're giving away money. They can't take it back from your church and stuff like that.
Correct.
But it's just children or grandchildren.
No, if somebody gives a big amount to church, okay, and so for those of you that, including me, give money to the church, are you gonna get penalized for doing $50 a week to the church in the basket? No. Are you supposed to get penalized? Yes. But when I have asked the Department of Human Services, and I see this treatment when I'm actually doing Medicaid applications, if you've got an ongoing history of a certain reasonable amount each month or each week, and you've done that for the prior 5 years, they are not gonna go back to the church and ask for the money back. But if you just found out you are going to the nursing home and you gave a $10,000 donation to the church for the building fund, yes, that church is going to have to give it back. Okay, and churches know these rules really well. Okay,
So part B of that question is, then what is the best way to give money to grandchildren or make an account for grandchildren? What is your recommendation for?
how do you give money to your grandchildren? You make sure that you aren't going to be leaning on the Medicaid system in the future. You make sure that you have self-funded your long-term care, either by having a good income, pension, or you've purchased long-term care insurance. But if your long-term care plan is to use Medicaid, then you have to be very judicious with what you give your grandchildren. If it's modest, like $20 a year, most financial workers won't care. But there is a reported case in Minnesota, in which an 84-year-old woman ended up in the nursing home and applied for Medicaid. And she had to report all gifts made in the prior 5 years, and she reported that she made $20 birthday presents to her grandchildren 4 years before she went into the nursing home. When she was 80 And the administrative law judge in the decision said she should not have made those $20 worth because of her grandchildren, because when you're 80, there's a reasonable chance that you're going to enter the nursing home. And if she didn't have long-term care insurance and resources, then it wasn't her money to give away. I know, don't kill the messenger. But know that this is an eligibility program. And if this is your long-term plan, because your family doesn't have resources to pay for nursing home care, then they don't care if you think those rules are a bunch of bunk. They're the rules. Okay, let's go to that.
So when we're talking about setting fair market value, who's setting that and how are they setting that? Are they using their tax value?
They're using the USDA charts for that year for irrigated, non-irrigated, or pasture. And your rent has to be within the range.
How, I'm talking more of like a personal residence or something like that. How are they setting a value on that and when do they set that?
If it is a residence that is in town, it can go off the true and full value on the property tax statement. Or whatever the public, a non-related family member would pay for it. But if on your true and full value on your property tax statement, it says that your house is worth $100,000, you know that the basement is collapsing and no one's going to buy it, and your son offers you $60,000 and you take it, that's a $40,000 gift. Okay? If it's rural property, then you have to have an appraisal or a dated, signed letterhead by someone knowledgeable in farm sales on what the price should have been.
And how about lake property?
Lake property, North Dakota, Minnesota. True and full value of the property tax statement.
I think we could go on with questions for a long, long time.
But what I was going to say is I hope this was helpful for you. Okay. And as we can see, a lot of what happens, I did a lot of seminars, and a lot of times we devolve into these Medicaid questions. I'm more than happy to come back if invited to do a whole Medicaid session. So you let Myrna know if that's something your community needs.
And what a segue in, we have a survey that my colleague Lauren is going to be handing out, and one of the questions is, are there other topics? I don't know about the rest of you. I feel like I need to go make an appointment with my attorney. I think a lot of us are probably thinking that. It's a lot of information. Susan, you are obviously extremely knowledgeable and articulate so clearly. So thank you to that again. Thank you to Jamie for all his work with our technology stuff. I don't understand how any of it works, but he made it happen today. And also to First State Bank of North Dakota, but to all of you for participating. As I said, the recording will be up probably the week after Thanksgiving. And so I bet many of us are probably going to watch it again, encourage other people to watch it, etc. So we look forward to doing some more of these. Our staff and community of care, we are not attorneys, but I know that our social workers have helped with just some initial steps in filling out, if you just have some paperwork, you got questions before you head to your attorney, I know that Lauren would be willing to do that, and our nurse is also trained to do advanced care plans, not from a legal perspective, but just helping you talk through some of those things. So thank you for coming. Will you please again join me in thanking you?
And in case there's follow-up questions, I've got the cards for you in my office. We'll give you that card.
The link to watch our website is just communityofcarend.com. It'll be right on our homepage where you're registered now. We're still working on a few technical issues in terms of exactly what format and how, but we would like people to register for that through our website because then we help to gather, web emails so we can continue communicating with you.
Questions, and I told him it's not been.